to charge whatever they want to charge. And so different states have different planning for probate, and so the prices range significantly. But it's pretty much a consensus that without a trust, assets will end up in probate if they don't have some sort of protections on them. And so we want to avoid that. Probate is also a public process. So, in a public proceeding, lots of people are notified about your client's passing. And if your client's settlement was well known, people are going to know your client had a lot of money and they died without proper planning. And now everybody gets to show up to this public proceeding to stake a claim. I had a case which was horrible. It was a husband and wife. They were married. We were going to start the process. They kept delaying, as I'm sure you know, clients always put things off. They kept saying they would. They finally met with me. I only had one meeting, and then the husband died. Now, you're thinking, well, hey, you said you're in California and been married, community property, right? Well, yes and no. She was not on title to anything. Their entire marriage, 40 years, she was never on a single home. She wasn't on a single bank account. She was on nothing. And so his assets, they all went to probate. And it's a public proceeding, like I mentioned, and so it turns out his father had an affair that nobody knew about and had a child in Tennessee. It's a public proceeding, a private investigator found the child in Tennessee. Now, the regular siblings, they go, we know that was my brother's wife. We would never take the homes from her. We disclaim. We don't want any of it. And you're like, yes, until the sister shows up that no one knew about. And she goes, I don't know this lady. I didn't know my brother. I didn't know my father. I don't care that this is her home. I want my cut. And because of that, she lost part of the estate. So probate is a mess, and it causes a lot of trauma. And being married doesn't mean you avoid probate. Okay? Putting children on your accounts doesn't mean you avoid probate. Which brings me to my next slide, blended families and children. So like I was mentioning, children, minor beneficiaries. This is a big one for people who think they're smarter than attorneys. They go, I don't need an estate plan. I have my kids on all my accounts. And I go, oh, how old are they? One's 5 and one's 21, but he's disabled. I'm like, oh, he has special needs. Yeah, he's good. He's receiving government benefits? Yeah, he's fine. Yeah, he's going to lose that when you die. And your minor, those accounts are going to go to court. So you're not outsmarting your attorney. I'm sure you won't deal with that. It's really fun having that conversation. You're not outsmarting anyone. So minor beneficiaries on the accounts is going to be a problem. And you might be dealing with parents who have just gotten a settlement and they're thinking, I'm good, I've got my kids on my accounts. And you might go, well, this isn't my realm, but I probably know that that's a bad idea. Let me point you in the right direction. And do point them in the right direction. Let them know that minors on accounts, children with special needs on accounts, it's a bad idea. We don't want all this money to end up in a court process. Minors can't inherit, so it goes through a process that holds the money for them until they're 18. And then there's no oversight. So again, if you get that client a $100 million settlement, do you really want an 18-year-old to get that money? I mean, that's just a recipe for disaster. We want to put it in a trust for them. The other one that's really big is, I call it unintended inheritance or unintended disinheritance. Unintended, and this comes from blended families. So if your client is married and maybe doesn't have any children with their current spouse, maybe they both have their own separate spouses, and they have joint accounts, and they're like, I'm good, my husband's on my account, no big deal. And you might go, okay, I don't do estate planning, I'm not really gonna get into that conversation. But lo and behold, she dies. She's the one who got the settlement from you, and everything goes to husband who is on account. Husband is not biological father of her children. So when husband dies, all his kids inherit her money from her settlement. And so again, that probably wouldn't have been a part of the plan. She could have easily left her husband as part of a beneficiary, children as part beneficiaries. She could have done all this proper planning, but the thought is for a lot of these people that win money, this is my first time getting money, I don't really know, I just know a joint account, and they're stuck. They don't have anyone helping them out in the next step of their life. And so we don't want to unintentionally disinherit one of your client's children because there was a proper planning in place. So that's